Good afternoon. The workshop meeting of the Board of Trustees of the McAllen Independent School District will be held Monday, April 23rd, 2018, beginning at 4 p.m. in the library, McAllen High School, 2021 La Vista, McAllen, Texas. At this meeting, there may be discussion by the board on the items and subjects listed as follows. And at 4:08, we'll call the meeting to order. Item number 2, discussion of the 2018-2019 budget. Dr. Gonzalez?
I guess, sir, at this point, I'll turn the floor over to Ms. Lorena Garcia to begin discussion on our 5th budget workshop.
Okay, we're going to go ahead and get started, Victoria. Today on conference, and I don't know if I can pull her up so you can get to see her. She's able to see us. We have with us Victoria Azenek. She is a partner with Rachel LLC. Y'all see her in the corner? She's one of the partners with Bracewell, and she is our school district bond counsel. So I just wanted to welcome her to tonight's budget workshop. We've invited her here to speak to us about business private use. As the district is considering changing the use of certain facilities and properties, we have to first investigate, make sure that it doesn't change anything in terms of the use where it would invalidate the tax exempt status of certain bonds. So at this point, we've invited Victoria and her team to help us assess all of the possible properties that the district has out there that is considering changing the facility use of, to make sure that we've crossed all our T's and dotted all our I's in terms of ensuring that the tax exempt status of our bondholders is protected. So I'm going to go ahead and turn it over to Victoria so that she can now walk us through her presentation.
Okay, sure. Good afternoon, everyone. Thank you for allowing me to join you today. As Lorena mentioned, my name is Victoria Azemek. I'm with Bracewell. I am out of our Austin office, although I am visiting you today from San Antonio. But I am here to talk a little bit about the private business use test. And my goal is to help everyone understand the major issues and not get too bogged down in the details, because I know that nobody wants to hear about tax law on a Monday afternoon. And so what we've done is put together a very high-level presentation with the hopes that, to the extent that you have questions or additional information that you'd like for me to share with you, I can do so either today or at a later time. But Lorena and Cindy and I have talked a little bit about the proposed transaction, specifically with Navarro Elementary, and then a couple of potential land sales. And anytime the use of a certain asset that's been financed with proceeds of tax-exempt bonds, if there's an action that's going to be taken with them, it's important to understand the tax implications that might cause for your bondholders. And so to give you a little bit of an overview, we'll move to the next slide. There we go. And this is really just an overview of the private activity test. The two major set of tax bodies of law that are that apply to tax exempt bonds are the private activity tests, which limit the amount of private use or private involvement that can be associated with governmental bonds and maintain its tax exempt status. This is under the theory that the federal government doesn't want to be subsidizing through tax exempt interest something that really is benefiting a private corporation or a private company. Their view is that private entities should be financing their own facilities through taxable debt, and governmental entities should have the benefit of tax exempt interest. So one major body of law in this area are the private use tests. The other deals with the investment of bond proceeds, and you've probably heard us talk about arbitrage and rebate, and that's the other main issue that body of law. But we won't really go into that today. But going back to the private activity test here, you'll see that there are three major tests. There's the private business use test, the private security and payment test, and the private loan financing test. And the first of those is a two-pronged test. So you will have bad, something bad will happen. Your bonds will no longer be tax exempt if the district or if the issue meets the private business use test and the private security and payment test. So that's a two-pronged test. You both need the bad use by a private entity, and you need to be making money off of that use in order for the bonds to be considered private activity bonds. And then the last of the tests, the private loan test, is an OR. It's a single-pronged test, and that has to do with districts or governmental entities that might be loaning money to private entities. But let me briefly go over what these tests entail on the next slide. So the private business use test, and this is the test that we're going to be focusing on the most today, is if more than 10% of the bond proceeds are used in the trade or business of a person other than a state or local government. So as you can tell by the up to nature of this private business use test, some private business use is allowable. But if you go over that 10% mark, that's where you can start to get into trouble. So generally, this is the first test that we look at because it's really the easiest to issue spot on. It's much easier to determine whether or not an entity is selling property or leasing property out than it is to measure on the private security or payment side. So kind of our first line of defense is to try to stay under the 10% of private business use with respect to any given bond issue. The second test is the private security or payment test. And really this goes to the amount of money that you might be making off of that private business use, whether it be in the form of lease revenues or the sale of land or a management contract, some other type of use. We look at the revenue that's coming off of that. And if more than 10% of the proceeds of the bond issue is secured by an interest in that property that's being used by a private entity, or is to be derived from payments in respect to that property or borrowed money used to be used for a private business use, then we've met the private security or payment test. This is done on a present value basis, and we really just look at that revenue stream. Some of you might be thinking, well, none of our bonds would ever be paid from the revenues we'd be receiving from a lease or from the sale of land. But that doesn't matter for purposes of this test. Even if these are general obligation bonds that are being paid for from taxes, we still have to take any revenues into account. This is sort of under the theory that all money is green. So even if you're not directly using revenues to pay off bonds, you would still need to take that into account on the private security or payment test. Now those two tests, the private business use test and the private security and payment test, that's the two-pronged test. So again, we try to make sure that we're under 10% private business use, but in the unlikely event that you go over 10% private business use, we try to make sure that you're not making money off of it. And then finally, there's the private loan financing test, which just says that more than 5% of bond proceeds or $5 million can't be used to make or finance loans to a private entity. That's the most I'll be talking about that one today because that's not what the district will be engaging in. Next slide. So like I said, we're going to focus the most today on the private business use test because that's the best place for entities to be able to issue spot and come to bond counsel and tax counsel to determine what actions should really be taken to avoid meeting the private activity test generally. And so private use can be broken down into several parts. It's direct or indirect use of bond finance facilities in a trade or business by a private person. And here what's important two things. First off, that a private person for these purposes includes nonprofit organizations and a little bit counterintuitively, the federal government. So if you enter into a contract or sell property with a nonprofit organization or the federal government, that's still considered to be private business use, even though that's not something that most entities would, immediately think of as business use. The other thing to keep in mind, especially knowing what I know about the potential transactions that you're considering, is that if you enter into a transaction with another state or local government, so with a county, another school district, a city, that type of use won't be considered to be private business use. That asset, after you've disposed of it, is still being used for a governmental purpose. There might be some bells and whistles that we would want to work into the sale contract in order to protect for future private use, but really we wouldn't have to count that towards the bad use in that 10%. Next slide. So I just wanted to highlight a few school district arrangements that could give rise to private business use. Now, this isn't exhaustive of all potential types of private business use, but these are a few that, based on my experience, tend to happen most often with school districts. The first is ownership and leases, management contracts, and then what we call other special legal entitlements, which really is the IRS's way of saying, we'll know it when we see it. But if we go to the next slide, I'll go into a little bit more detail on each of these. The first is ownership and leases. And so private business use results when a non-governmental person is the owner of bond finance property. So this would be if the district were to sell property to a non-governmental entity. It also includes arrangements with non-governmental persons, that are characterized as a lease for federal income tax purposes. That may include a management contract being characterized as a lease if there's sufficient amount of control by the manager. Really what it gets to is under the benefits and burdens test of who has the benefits of the ownership of property and the burdens of ownership. And so any type of arrangement that would meet that benefit and burdens test under federal tax law could potentially create private business use if you're disposing of that property. Next slide. Second is management contracts. And a management contract is a management service or incentive payment contract between a governmental person and a service provider, under which the service provider provides services involving all or any portion or function of a facility. And so in general with school districts, we see these in the forms of food services contracts, sometimes with bus services that are contracted out. Sometimes we see management type contracts with respect to after school childcare. And if that arrangement is with a private person, that could potentially lead to private business use. Now, this does not mean that every management contract creates private business use. Really what the IRS looks to is whether or not that manager or service provider has a net profits interest from the operation of the facility. There's a large body of tax law that deals with whether or not a management contract is what we call a qualified management contract. And so depending on when the management contract was entered into, whether it was an older contract or a newer contract, we have a couple of revenue procedures that give us safe harbors that we can meet. And generally those safe harbors go to structuring requirements that simply ensure that the manager doesn't have a net profits interest in the facility itself. So generally, if you're paying a fixed fee per month to a manager, you wouldn't have any problems under the management contract rules. However, if you have a manager that has a real incentive on both the revenues and the losses side to maximize their profit in the venture, then you might start getting into problems with private business use with management contracts. Next slide. Finally, we have the other special legal entitlements. And like I said, this really is a rather amorphous, undefined body of law in terms of the IRS has just identified certain arrangements for either the priority of right of use of a facility, Really, a lot of it is dug in on control of the facility, and if there's a special economic benefit given to a private user with respect to the facility. One thing that I wanted to highlight here, because I know that you all are considering naming rights with your stadium, is that there is a revenue rule or a private letter ruling that was issued that deals with naming rights and the fact that they can, if structured in a certain way, create special legal entitlements. Now, if you are simply selling the right to have a name on, a stadium without any other type of control wrapped into it, I think that most tax lawyers would agree that that's not the type of special legal entitlement that the IRS is worried about. However, if part of the contract gives control regarding how the stadium is operated, how the stadium is used, and really, it's there's no, like I said, it's a facts and circumstances test. There's not really a good bright line.
They have a question.
With
I'm sorry.
respect.
We have a question on the,
Sure.
on the naming rights.
Okay.
Thank you. This is Sam Saliva, one of the members of the trustees. The reason I stopped here is I just want clarification. We're not changing the name or giving naming rights to the stadium. It's to the field. So the stadium still remains the name it's been given, which is McAllen Veterans Memorial Stadium, and then that's, it's flipped, in other words. So the stadium still remains the same. Does that change what you're telling us? Or is there some other statute that would apply?
They would not, we're not.
I don't know that it necessarily changes what, the basis of the private letter ruling itself, because, we have looked at naming rights outside of stadium naming rights in terms of naming rights of all sorts of different facilities. There are naming rights of rooms, and believe it or not, an oil rig on a campus, like on a community college district campus, was named after a corporation. But really the basis of it, and setting aside what exactly is going to be named, it again goes back to control and whether or not that naming right will simply be kind of an honorary name on a field.
Yes.
Or
Yes.
whether or not the entity for which that field will be named will have some sort of control over, let's say, they are able to use the field 5 times a year, and you have to operate the field in a certain manner. The more control that an entity who is paying for the naming right has over the property that's being named, the more we ventured into, impermissible naming rights that have to be considered private business use.
All right, thanks for clarifying. And in our case, that's all been concluded in the contract, so they have no control whatsoever. It's an honorary naming, that's it. Thank you.
Okay, perfect. Okay, so we'll move on to the next slide then.
One moment, we have a second question.
Oh, sure.
I'm sorry, I was wanting to ask a question before, and this is going back on
Okay, no
on the 10%. So if we're using bond money if we used bond money to add an additional wing to a school, and that school we want to repurpose, does the 10% only apply to that school or to the entire bond?
That's a good question, and I'm going to cover that in a little bit more
Okay.
detail later. But
Okay, no, that's fine.
Again,
You can cover it
Okay.
later, that's fine.
okay, I will circle back. I'll point out when I'm covering this basic question.
Okay.
Like when I get to that.
So
But
I have
that's a
an-
good question.
I have another probably basic question, but it was going on to if we sell a property to a government entity, it doesn't hurt the 10%, but what if there's a profit made? Does that affect us in any way?
That's a good question. And if you make a profit off of selling it to another governmental entity, that shouldn't create in and of itself any event that would create a need to remediate those bonds. And I'll go into a little bit more detail about what remediation is towards the end of the presentation. What we would want to do in that sort of instance, though, is be very careful about how the entity that you're selling the property to or is using the property, putting restrictions on whether or not they can resell the property or sublet the property to another user. Because if you are entering into a contract with another governmental user, that doesn't create private business use. But if they turn around and either sell the property or sublet the property or have bad private use on that property, well, then that could create problems for your bonds. And so we can talk a little bit about, you can have covenants in your sale agreements and that sort of thing that make sure that they would come back to the district so that you would have the opportunity either to prevent that use or remediate the use at that time. Did that answer your question?
Yes, it did.
She's only referencing
Okay.
those that are outstanding bonds, not property.
Okay, any more
paid off
questions?
from bonds.
I'm happy to answer as we go along.
Okay.
You may continue.
Okay, well, I'll just keep going then. So there are some exceptions to the private use rules, and I've highlighted the bigger ones on this next slide. First off is general public use. So you don't need to worry about business entities that might be using property in the course of their business. Parking lots, just because somebody is driving their company car and using the parking lot, that doesn't create private business use. Or an entity that is, like somebody who's coming in to fix something on one of the campuses. That's not private business use just because a private entity is, benefiting from fixing the sink, a leaky sink in a bathroom or something like that. Now, incidental use is another type of use that we don't have to take into account. The example that's given in the tax code, which is a little bit outdated at this point, is a telephone booth, which of course we don't, telephone booths are hard to come by nowadays, but there are similar types of things that we consider to be incidental. Good examples are ATM machines and vending machines. So even those might benefit a private entity because they're located on a campus. Nonetheless, they're incidental to the operation of the facility and aren't considered private business use. Likewise, if you contract with a janitorial company or somebody who's essential for the operation of the facility but isn't using a discrete portion of the facility, that would also be considered incidental use. And then finally, short-term use. And with school districts, what we see a lot of are performing arts centers, for example, might be used for a weekend by a dance school for recitals, or a family reunion might rent out, the cafeteria. Things of that nature, anything really not exceeding 50 days, wouldn't be considered private business use because it's a short-term basis. And again, this goes back to that basic theory you might have noticed as part of this presentation. A lot of what we look to is the amount of control a private business entity has over the property in general. So the idea is that if an entity is only using the property for less than 50 days, there's only so much control that they really have over that property. Next slide. So, and this is getting back to the question that was asked earlier with respect to, how do we really measure this private business use? I tried to keep it high level here. I will say that the rules are very specific and can get very, very complicated quickly. But in general, the level of private business use is determined as an average. It's the average percent of private business use during the measurement period. And the measurement period is generally measured from the issue date or the placed in service date of the asset through the date that the asset is no longer, it's exceeded its useful life, or the date that the bonds mature. once bonds have matured, you don't have to measure private business use anymore. Where this can get tricky is if you have a refunding of your debt, because when you refund your debt, you have to look back to the original asset financed, and that can extend the private business use measurement period. But it is an average that's taken over the life of those bonds. And so one thing to keep in mind is that if you have excess use, more than 10% in any given year, that can be offset by the fact that you didn't have more than 10% or you had no private business use in previous years. And so it's an averaging concept. So sometimes issuers who, let's say, sell property in a later year, the fact that they had no private business use early on actually offsets it such that the 10% overall isn't exceeded. And the next point, and this really gets to the question that was asked, is that the measurement is completed on an issue-by-issue basis, not on a facility-by-facility basis. So by issue, I'm talking about the bond issue by bond issue. So if a portion of a facility was financed by the 2005 bonds, well, really, we look to see what other assets were financed with those 2005 bonds as well, and we look at it in its totality. So just because a certain facility might have 100%, 50% private business use, if there were a lot of other assets that were financed with that same bond issue, it might be that we're lower than 10% overall.
Okay. I have a
And
quick question.
this can be,
I'm sorry.
Sure.
Just because we keep talking about 10%, is it 10% of what is owed or 10% of the entire amount of the bond?
it's 10% of the gross proceeds. And so the gross proceeds of the bond are the amount that you receive at the sale, plus any investment earnings that were earned before that they were spent on a project or some, in the course of spending all the money. And so we look at how the gross proceeds were allocated to assets to determine how to measure that private business use.
Okay, so if that bond has been existing for 15 years, we would take into account the 14 years that we haven't used it at all, right?
You could, yes. And so the fact that you might have had 0% private business use over the course of, the 15 years, you have only 5 years left, well then, by law of averages, we might be lower than the 10%, depending on how much of the bond issue was used for the asset. And again, I tried to keep this presentation relatively high level because it's very easy to go down into the rabbit hole of the nuances. But another thing to keep in mind is that there are actually measurement rules that are associated with the facility itself, because a bond issue, if you're building a new school, generally you have a bond issue that's allocated to building the new school. But there might be, if you're only renovating a certain wing with a bond issue, well, we track to see, if the bond issue was used to renovate a wing of a school and you're leasing out a completely different part of the school, well, then that might not create private business use. So we sort of follow the bond proceeds to the asset that was actually financed. And so there's a lot of rules regarding what you do with common space, what you might do with space that's used by a private entity 50% of the time, and the rest of the time by a governmental entity. So there's a lot of very complicated rules that go into how we have to measure this private business use. But what I've tried to focus on here is how to identify it, and then kind of with broad brushstrokes how we measure it.
This is Danny Bell. I have a question. When we're getting ready to go into a private use of one of the facilities, do we have to send this for someone to give us a test and test to see if it falls under these guidelines or not? Or is it something that would be triggered later on? And if it is triggered later on, who makes the determinations on whether or not we meet these measurements. And then
Well, generally what we have.
I was gonna,
oh,
my
I'm
follow-up
sorry.
question to all of that was, if there is a repayment or a refund, what is that amount and how is that determined?
Okay. So to answer your first question in terms of what triggers all of these tests, what we advise clients to do is, and part of why we try to educate regarding what the private business use tests are and how to issue spot, is that it's always a good idea to come to bond counsel and ask, does this create private business use? And many times our response is, well, for X, Y, and Z purposes, you don't have to worry, about this use. Either you're contracting with a governmental entity, this is such a small portion of your overall bonds that it's not sufficient to, meet the 10% test. But we generally, give some advice regarding how to measure that use. And for the most part, if issuers if we're not close to that 10% test, we advise issuers just track it. You don't need to do anything differently with respect to your bonds other than hold on to that contract that might create private business use. But if you're not close to the 10% test, then you can, go along business as usual. Once you start getting close to that 10% test, that's when we start advising for, more careful tracking of private business use. And in some cases, potential remediation. And let's see, I think the next slide, why don't we go to the next slide? And I'm hoping to answer your questions in the next couple of slides. And if I don't, we can circle back to it. So one thing to keep in mind is that this is a two-pronged test. And so in many instances, if an entity has exceeded the 10% private business use test, we turn to the private payment test. Because generally you have to be making money off of these transactions, and oftentimes, simply put, governmental entities aren't making enough money off of these transactions they're entering into in order to meet the 10% private payments test. And there's some measurement tools within the private payment test that we can be useful. For example, you're allowed to offset private payments, say lease payments. You can offset them with the operation and maintenance costs that might be associated with that facility. So you can sort of whittle down the payments that you're receiving from these private entities. It's also measured on a present value basis. So if you're entering into a lease, 15 years down the line, the present value of those lease payments will have a smaller effect overall. So again, there's a few measurement tools on the private payment side. And if, even if you have 15, 20% private business use, if you're not making a lot of money off of those arrangements, then again, we might be able to advise our clients that you don't have to do any remedial action. At this point, you just need to make sure that you're not, if your payments ever increase, we'll have to revisit the calculation. Next slide. There are also some other things that you can do to address private business use concerns. And the first two on this slide are reallocation and contract negotiation. And these are do-it-yourself sort of corrective actions. Reallocation involves reallocating the bond proceeds to a different asset. This is really only useful if you're going to figure out that you have private business use within 18 months of the bond being issued. But there might, if that's the case, there might be time to reallocate the bond proceeds to a different asset. Now, if you have a bad management contract, one that doesn't fit within the safe harbors, you might be able to renegotiate that contract such that you do fit within the safe harbors. So that's another way that you can kind of deal with bad private business use. And finally, there are remedial actions. And those are actions that the issuers can take to remediate or cure the bad use. And I'm going to go into a little bit more detail on those on the next slide. And so a remedial action involves taking the disposition proceeds or the payments that you're receiving from the the action that you're taking, the change in use, whether that be disposition proceeds from the sale of an asset or lease payments that you're receiving from a lease that you've entered into with respect from assets, and using them for another good purpose. So there's a few threshold requirements that an issuer has to meet in order to be able to take a remedial action. You can have expected the bad or the private business use at the time that you issue the bonds. The maturity date of the bonds has to be within a reasonable term. You have to be receiving fair market value consideration for the arrangement, whether that be sale or lease. For the period of time that you might have those disposition proceeds on hand, you have to yield restrict them, so you have to treat them as gross proceeds for arbitrage purposes. And the proceeds of the bonds have to have been expended prior to the deliberate act. Now, most issuers don't have any problem meeting these threshold requirements. But then there are, what can you do at that point to remediate the action? And by remediation, I mean, you can move on as if there was no private use associated with that bond issue at all. The first option that you have is to take the disposition proceeds and use them to redeem or defease the non-qualified obligations. And by non-qualified obligations, I mean the portion of the bond issue that is allocated to the bad use. So if you used 10% of your bond proceeds to finance, a building that was later sold, well, then you would use disposition proceeds to redeem or defease 10% of your bonds. Another option would be to find an alternative use of the deliberate act proceeds. So those disposition proceeds or those payments that you're receiving, you would use them for another governmental purpose that's capital in nature. So if you had a new, if you sold a school and you have a new project for a new school, you could use those disposition proceeds for another good governmental use. This can get tricky with lease payments, of course, because you're not receiving a chunk of money all at once. And in fact, there was literally a couple of weeks ago, there was a new remedial action revenue ruling or procedure that was released that deals with that, allowing you to take the present value of the lease payments and to use those for alternative uses. And then finally, there's the option to have an alternative use of the facility. And this really is if you are, let's say you're selling it to a 501c3 entity, they can separately qualify as good use if certain types of or certain requirements are met. That's probably the least used of the remedial actions. For clients that have worked through remedial actions before, generally it's either a redemption or alternative use of the proceeds. Now, some issuers choose just to, even if they're not going to meet the 10% test, some choose to remediate just, to mitigate risk and exposure in the future, but certainly it's not required unless you meet that 10% test. I believe that Lorena has provided you with an article that we had written about giving an overview of of the remedial action rules. So it provides a little bit more detail about the options that might be available if you have bad private business use. And with that, did I answer your question, the gentleman who last asked the question?
Marco, Dan.
Yeah, pretty much. The refund amount or the penalty amount should be minimal, even if there was a situation where we had to pay something back, according to the explanation. And one more question came to mind, and that was if the original bonds were in 2005, but they were refinanced subsequent to that, does that start the clock all over again, or do you go back to the initial 2005 date?
It doesn't start the clock all over again necessarily. There are a couple ways to measure with respect to refundings.
I don't think there's a penalty.
If-
We have to move it out of money
You have two
to cover
options.
it.
If you issue bonds in
Like auto
2005
refund.
and refunded them in 2013, which
Sue us.
if memory serves is the case here, then you can have what we call a combined measurement period where you measure private business use from, 2005 onward. And that could be beneficial, especially if you didn't have any bad use in those early years. Now you have the benefit of, the averaging in order to take advantage in terms of all those years of no bad use. There are other issuers for various reasons. If you didn't have any bad use with your original bonds and then refund them, there is an option to kind of start the clock ticking all over again. But in most cases, that's really not advantageous to the issuer.
I have a question, Victoria. So if we
Mm-hmm.
were to consider to change the use of multiple facilities, would the 10% be, it would be cumulative, right? We would take all of those and, that would affect the 10%?
That is correct. So assuming that all of those facilities were financed with the same original bond issue and, are all associated with the same issue of bonds, you would have to, look at the cumulative effect of all the private business use. So if you have, 2% and 6% and 5%, well, once you add them together, you might exceed the 10% test overall. And that's why it's really important to understand that, this is measured on a bond issue by bond issue basis and not necessarily a facility by facility basis.
And going back to the Novato transaction, from the information that we've given you already, would you be able to give us your opinion, whether you felt that was business private use?
Sure. I did take a look at the lease that you sent me, and from what I saw, and granted, I haven't had the opportunity to do a lot of research about the Head Start program generally, but from what I saw, that would be considered a lease to another governmental entity. And so while you might want to work in some protections in there, like I was saying, to make sure that Head Start doesn't turn around and sublet or have a bad management contract with a private business user, the lease with Head Start itself should not create private business use. But it's always just a best practice to incorporate a few safeguards in the lease to make sure that you can keep tabs on and any potential private use of that facility.
And you can help us with that language, correct?
Oh, of course, yep.
Thank you.
And really, it's not terribly complicated language. It's just, a provision that, depending on what's negotiated, generally we try to have them, we affirmatively state that both parties understand that the facility was financed with tax-exempt bonds, and so there are limitations on private business use, and that that the counterparty would come back to you with any subleases or management contract type arrangements to get sign off on.
Great. Any other questions from the board? Okay, well, that concludes this section of the workshop, and we really appreciate you being with us today and educating us on this topic.
Okay, thank you for having me, and I know that I probably created as many questions as I answered them, but surely if there's any follow-up that you need me to do, I'm happy to provide more information. I was really just trying to be as brief as possible, on this topic, but still give good information.
Well, thank you. Thank you very much.
Okay, thanks everyone for the opportunity.
Thank you.
Thank you.
Yep. Dr. Gonzalez, they're only going to use a portion of it. the newer section. We're gonna retain use of the other parts.
Yes, sir, we're gonna have the majority will be utilized by special education. Not the majority, but the 14 classrooms.
But this is pretty good in moving forward, so we know when we wanna, if we wanna sell land, what our options are,
Exactly.
how to sell it, or who to sell it to.
Or if we're gonna have somebody use it for private use, if we're restricted from it, and to what extent we have, that's important.
I don't think no bond money is being used for Austin, right?
No.
For the property on Austin?
No, there's a list here and it's not in there
Yeah,
at all.
it's not in there, but Dickman is, the old Dickman is,
The old pit?
yeah, the old.
Oh,
Dickman.
because of the pavilion?
No.
No. And then, you know, if we talk about like the 6th elementary land, changing the use of that, you know, as we start adding properties to the list, that's why I wanted y'all to keep that in the back of your mind, that this is something we'd have to keep track of. And the other item that I have for you is I created a little handy timeline chart just to keep all these important dates in regards to our debt service plan. And it's up on the screen. It's a two-sided. And what I did is I started with 1890 and identified key milestones or events in regards to debt service. We have in 1819 our bond payment drops from 9.9 to approximately $9 million, which would be a savings of $898,300. At the same time, our debt service state aid, our for facilities funding, drops to less than 1% to 0.4%. So the district is paying for the bulk of that bond payment with very little assistance from the state, whereas other districts get a much larger percentage. McAllen ISD does not. And then in 1920, that amount is at 7% because this is based on a projection of $1.04 and an 11.5-cent debt service. Now, if a permanent tax swap were to be approved and that debt service tax rate would go down to 0, then you're probably looking at more in line with the previous year, another 0.4 versus 7. So, and then that same year, of course, the bond payment drops again. So this is where the district would realize some savings. That $2 million and the almost $900,000 that we would no longer have to set aside for the bond payment could then be utilized or repurposed for another maintenance tax note without impacting the local taxpayers. And then that funding could be used for facility improvement projects. Then
Mr. Jose Martinez, please come to the front office. Mr. Jose Martinez, please come to the front office.
2020 and 21, debt service is 1.5%. Again, assuming that there's tax effort on that side, otherwise it's going to be 0. And then by 2021, 2022, the district will no longer see state aid for debt service. The bond payment 100% will rest on the district's expense. But in 2022, you know, you all had asked about when is the earliest that we could do a bond refunding. Well, our bonds are callable as early as February 15, 2023. So that's the earliest we can evaluate whether that would be advantageous to the district.
And that's assuming the TRE is passed, right?
No, well, that is our outstanding bond debt with whatever the tax rate is, regardless of the tax rate.
Actually, I'm talking about 21, 22, which is state aid for debt service. If a TRE is in place, right?
That
If
would
it
be regardless. That projection is even at 11.5 cents. It would end. We would no longer qualify for debt service, state aid. So that's the best picture. If we have a tax effort on the debt service side, if we reduce the debt service tax rate to 0 permanently, then that picture gets even worse.
We'd have money earmarked on the M&O side to pay bond debt. moving
Yes,
forward.
we would use surplus maintenance and operation revenue to still meet our bond payment obligation. So on the next side, you can see that our maintenance tax notes that we currently have outstanding, the QSEN 2011 and 2012, would be maturing in 2025, 2026. So that's about roughly a $2 million payment that again the district could then repurpose into another maintenance tax note and continue to do facility improvements without having to go out to the taxpayers for an increase. And then finally in 2029, 2030, that's when our bond debt matures, and there's that final payment.
And so 25, 26, with that extra 1.9, you could fund up to $20 million?
That's
More or less?
just an estimate.
Okay.
You know, of course, at that time we'd have to get more concrete figures, but I'm basing it off of the current tax note and the payment, keeping it in line with that.
Just for clarification, on a maintenance tax note, if we wanted to build a structure, we're allowed to do that, it's only within the four walls of previous structures that have already been built. You can't build anything new or add to.
That's correct. It's working with the existing footprint, so you could do anything inside it, or like replace roofs. You could replace chillers. Break down walls and move classrooms around. Maybe if you were to, like for example, a science lab example would be if you were to take existing classrooms and combine them to create science labs, that would be allowed. But if you wanted to add a wing, then you could not finance it with a maintenance tax note. But what the district could do is utilize a maintenance tax note for facility improvements, and then use general fund to do additions.
And I noticed on the list on that PowerPoint, prior to the 2005 bond, they listed some improvement. Was that from the prior bond? Or it wasn't quite clear the list before 1998, 1999?
Yes, those were prior bond projects, and
Have those since been
98,
paid off?
99.
Have those since been
well,
paid
part
off?
of that was, some of that was still in the 99. I believe we still have some as part of the refunding.
I see. So we brought some of that into the 2005 bond?
Cindy, do you want to come up to she has a little more detail on the history of that, on the refunding.
Yeah, and I think I even brought some, let me start to have it here. We do have the 98 and the 99.
Yeah, we're just doing the research for the past couple of weeks. As part of this conversation,
No, I don't think I got it with me. But
This
we,
is very good.
yeah, but we do know that we did speak to Victoria, and we have spoken to Dusty Trailer, our financial advisor. So we have been in communication with our financial advisor and our bond counsel regarding the private business use issue. And they do have some of the 98 and the 99 refunded in the 2005 bond. So we're going back and making sure, and Lorena, I think, did you have it on this PowerPoint, the projects that are on there?
Yes.
We actually have a listing of the projects that are in the 98 and the 99 bond, which you'll see there at a glance. You want to go one?
Yeah,
Is
these
it
are,
the one before cap?
that's
So
the
you're gonna
98,
see-
99.
You're gonna see the 1998 projects that were completed, and you're gonna see the 1999 projects that were completed. And we pulled this out because now we need to consider what buildings were affected as we consider selling or leasing any of our property. So we've got a listing of those in there, and if you go to the 2005, you're gonna see that complete also on there. We have some other small projects, and we were able to go in there and identify which ones they were and the amounts that were associated. So when we're speaking to them regarding the Novato project, you'll notice in 2005, Novato is listed on there. I don't know if you can place the pointer to it.
Can you make it a little bit bigger?
It's under the renovation section, the fourth to the bottom.
Oh, yes.
Novato 2.1, I think. 3.1. So she factored that in right there, right? And if you flip it back, Lorena, to.
That was that, I'm sorry, Ms. Richard, that was that central piece that was made, that total new construction?
Yes,
That's what it
exactly.
cost?
And that's why you're seeing the large dollar amount on there. And yet, if you go back to 99, Lorena, you're gonna see there was a small project in 99 for Novato, right kind of in the center for 716,
Yeah, I see.
710, 710. So they were looking at the small renovations that were done there, and we don't see anything in 1998. So we're actually having to go back to our older projects and determine, based on what facilities y'all are looking at, where this is gonna fall in there. But yes, we still have some of that in there. And until that retires, we have to consider the private business use tests on
We were
those.
kind of hoping to exclude,
Yes, bond pays.
we were kind of hoping to exclude the 98, 99, but in doing our research, we found out that, you know,
They were
they're
in there.
still in there, so we.
But the amounts were
Try to make the
small,
task
so
a
they
little
were feeling
easier.
very confident, right, Loretta? The amounts were small, so they were feeling very confident that for the most part, we won't be as affected by those.
Mhm.
And also because of some of the dollar amounts associated with the facilities we're looking at there. We are right now, my staff, and hopefully we'll get that done within the next few weeks. We're looking to break down what makes up the other small projects in the 98 and the 99. We did it for the 2005 because we were thinking that was the only one affected, so we wanted to see very quickly what other buildings were affected. So hopefully we'll also have those breakdowns for those smaller projects, but we're having to dig into older files to pull that together.
Do we still have records or able to go to exactly what was done on those campuses back in 98, 99?
Yes, sir. Bond records are permanent records for a school district. So, I mean, they're in file cabinets and all that good stuff, but we do have hard copies.
And from the M&O side or the construction side of those projects, we can break it down to toilet was replaced or whatever was done?
You know,
Do we go that far down?
I
or-
don't know if we have, I don't know if we have that type of detail.
Because I'm trying to understand
Yeah.
what we might have done
Would
to
have
what
done for
part of
them,
the building.
yes. I don't believe I have it for 98 and 99. We might for 2005.
On the facility sides, they would, because their blueprints, they're required to keep them, construction
Okay, so you can
documents
keep those,
permanently,
okay.
so.
So the detail will be by
so
the end.
They
Okay.
should.
But for purposes of the conversation we're having at this moment, we don't need to go to that finite detail.
No.
We only need to go to the fact that it came out of the bond and what it not was.
Exactly, you're right. That's what we.
And then how many properties we're considering, and then put together, does it get us close to the 10%, or, you know, at least, to get us to a point where we're tracking that for future changes in facility use.
Now, based on this plan, looking at it, any of this coming to, as an issue?
We don't feel at this time that there's any issue, but we wanted to bring it to your attention as additional properties are being considered, so that we can continue to track that.
But for at this time, it doesn't.
It does not.
She's reviewed the properties.
Yes. Well, we've sent her we told her the properties that were being considered. We gave her this list as well. And we went over the three that are in the Big Pen, the Austin one, which is not even on here, the model property, and the special ed one. Yeah.
It's only the Nevada is, right?
Okay, we have to open the 5 o'clock meeting,
Yeah, we have to go up there.
so we need to step out.
So that was all I had for you,
That's all you
unless
have?
you had questions.
I'm sorry, that's it, that's all.
Okay.
You open the meeting on the property.
Only 40 to go.
Well, we're gonna close this one right now, right?
Yeah, we gotta close this. I move,
Can I get a motion to close the workshop?
move to adjourn.
We have a motion from trustee Vela, a second from trustee Saldivar.
Alvarado.
Alvarado, all in favor signify by saying aye.
Aye.
All opposed, same sign. The ayes carry it 6-1. At 5:06.
It's the tax.